Witness is yours.
Thank you. Do you recall your deposition being taken back on June 23rd of this year?
I recall the deposition. I'm not sure the date, so I'll take your word for the date.
You take my word for it?
Just for the date, Mr. Taylor.
I asked you when you began working for Summit, and you said June 1st of 2021. Is that correct?
Yes.
And I asked you what the status of the project was at that time, and you said it was a conceptual project, and that there had been a feasibility study. Do you recall that?
Yes.
And you said that the feasibility study was done by a wood company. Is that correct?
Wood Group.
Wood Group. And all companies are groups now, aren't they?
I think Wood they've consolidated multiple companies over the last few years, and they keep changing their name and the look of their name, lowercase, uppercase.
In any event, after that deposition, I asked in a data request for the report that Wood provided from the feasibility study, and Summit responded that there wasn't a report from Wood. So I need to ask you, what information did Wood provide Summit as a result of that feasibility study?
Yes, Mr. Taylor. They provided a feasibility study. It was very high level. I thought we retained a copy. We had not contacted Wood. They couldn't seem to find a copy. But essentially, they generated a very loose route. And when I say loose, it was traversing through barns and properties and those types of things, and a very high-level cost estimate and a very high-level schedule. So I did use the word or the phrase feasibility study, but it was much more high-level than that.
So what was the purpose of it?
To validate to Summit Ag at the time that a general order of magnitude for cost and schedule and constructability, so that Summit Ag could continue to develop the project. And that's when they brought on the management team, including myself, to refine that work product, do a lot more work, put a lot more effort into it, and determine if there was a viable economic project.
So when did Summit Ag first take a look at this idea? Do you know?
I do not know, but my recollection, it was sometime in 2020.
Then, in response to a question from Mr. Jorde, you said that Terracon had done some work to lay out an initial route. Exactly what did they do in making that investigation?
Pivot is the tool, and Pivot, in my opinion, is the best routing tool in the industry at this time. And so they have all publicly available information, some proprietary information, such as eco-sensitive information from PHMSA, etc. And then they have routing information that's much more specific than just REX tag of existing pipelines. And so they can run multiple iterations of a pipeline route from one point to another, and they can take into consideration those preferably avoidable areas like federal grassland easements and those types of things. And so it's a good first pass at a route.
Did they provide a report?
They did. So every iteration of the route, there is a report that's essentially X number of crossings, X number of any kind of feature.
Yeah, do you recall when they did that?
I'm the one that brought Terracon or Pivot into the project. That would have been third quarter of 2021 for the initial route.
So is Pivot a company, or is it the method or program or model, whatever you want to call it, that Terracon used?
Well, the program and the company were synonymous at one point. So a group of individuals developed the program, and then it was called Pivot, and then they subsequently sold that product to Terracon.
I see. Okay.
I believe that's the lineage.
You said that the dispersion modeling is not for route selection, but simply to satisfy the PHMSA requirement for HCAs. But don't you think that the results of the dispersion modeling would help the board here decide whether or not the pipeline is being routed in the right place to protect landowners and others and protect property?
Mr. Taylor, I'd like to rephrase what you just said. I didn't say that it was simply to identify the HCAs. I said that the dispersion modeling is a tool to identify risk. And then we have to take the design considerations, construction and operation considerations or activities that we plan and mitigate the risk. And so the dispersive model, if we, in using that, identify that the risk can't be mitigated to the satisfaction of PHMSA or the IUB, etc., then we consider other alternatives.
So if the dispersion modeling results persuade the IUB that they don't like that route, they can change it, correct? Or they can force you to change it, just like North Dakota did, correct?
Well, I'm not going to project what the IUB can and can't do. I will say this, as you know, there are 230,000 miles of hazardous liquid pipelines in this country. There are 47,000 miles of pipeline in this state. Many of those run right through cities, major cities. And so they can coexist. And as we've said before, pipelines have an extremely high reliability record and an extremely good safety record. So pipelines can coexist with urban areas, metropolitan areas, populated areas. It comes down to how you identify and how you manage risk. And that's where the dispersive model is valuable.
Remind me, did Dakota Access go through any cities?
Well, I can't remember exactly where the 343 miles were routed through this state. I'm sure they skirted close to, if not through. But I do know in South Dakota they're a heck of a lot closer to Sioux Falls in some areas than the Summit Pipeline. And I will remind you that that's a large diameter crude line, and in my opinion, introduces a lot more risk than the CO2 pipeline.
Well, it may be that an oil pipeline would have a leak or a rupture, and the oil would spill out and flow. But oil is not an asphyxiant, is it?
But it's flammable.
It's not toxic, is it? Unless you drink it, I suppose. But I mean, just exposure.
Well, it's a different risk profile, but it is a high risk profile if, in the likely event, you have a release and you have an ignition source.
And natural gas is not a hazardous liquid, is it?
No, not natural gas in gas form. It is a simple asphyxiant.
Have you seen any dispersion modelings for natural gas leaks or ruptures?
I have been involved in natural gas projects and other natural gas liquid and other liquid projects, crude and refined products projects, where we've done EFRD and release modeling, again, to identify the risk. But I've never shared those models. Even with first responders, Mr. Taylor, you don't have to show them the detailed output. What first responders, in my experience, and Mr. Dillon can speak to this better than I can, but in my experience, what they want to know is, where is my containment area? Is it 330 feet, like the response book says for CO2, or is it something less or something more? What could be the potential impact in certain scenarios, and what kind of equipment and resources would I need to respond to that?
But nearby residents or property owners would want to know how far that CO2 is going to disperse, wouldn't they?
And that's part of that could be part of a public awareness campaign, is that you say, if there were a release, you take this action.
But
and that's part of a reverse 911, their means of notifying residents or potentially affected parties.
The people can't know that unless they know the dispersion modeling results, can they?
Mr. Taylor, I keep coming back to the same thing. There are 47,000 miles of pipeline in this state, and I would think it's probably a high probability guess on my part that none of the impacted residences in and around those pipelines have ever seen a dispersion model or a release model or an emergency flow restriction device analysis.
Maybe they didn't know enough to ask at that time.
Well, or maybe it was used for the intended purpose, is to identify the risk, and then you've got regulatory bodies like PHMSA, like the IUB, like other agencies, and you've got your first responders and your emergency planners that help manage that risk, and the operators, of course.
He told Mr. Jorde that PHMSA either recommends or prohibits the release of the dispersion modeling results. Can you cite me to the PHMSA rule or whatever you're referring to?
We can provide that. I can't cite that for
you. Is it a rule, or do you know?
Again, we can provide information that I'm using to formulate that response.
You talked about claiming that PHMSA has a 50-foot setback rule. Isn't it correct that that rule is a standard for the depth of ditches and not a setback?
Well, that setback is coupled to a 3-foot depth of cover.
Well, basically what it says is that if the pipeline is closer than 50 feet from a structure, that the ditch has to be deeper, correct?
Well, it doesn't say that, but it does say, if I remember correctly, that if the pipeline is very deeper, that you potentially waive that setback requirement.
Well, I suppose that's another way of looking at it, but the same thing, that if the pipeline is closer than 50 feet, the ditch has to be a certain depth, correct?
It has to be deeper than 3 feet.
Yeah. But PHMSA isn't saying that the pipeline has to be 50 feet away from a structure.
Correct. At least that's the way I interpret it.
And that's right. You said that the purported benefit of this pipeline is that there'd be higher land prices and higher corn prices because of the benefit to the ethanol industry. Was that a fair statement of what you said?
Well, what I hope I said was that by helping the ethanol plants remain viable, expanding their markets, that we could sustain the price of corn and hopefully sustain land values. And if they're able to expand and drive up the demand for corn, that may increase prices, may not. May increase land values, it may not. but I know I don't know, but just on history, if the commodity price significantly reduces, I mean, most value in this state is tied to the corn suitability rating, most ag land, so you've got to have a market for that corn.
Well, if there are higher land prices for farmland, doesn't that make it harder for young farmers to get started?
I can't speak to that, Mr. Taylor.
And if there are higher corn prices, isn't that a disadvantage to livestock producers who buy that corn to feed their animals?
I don't know. I can't speak to that. You're talking about dry distiller grains?
So one person's benefit could be another person's detriment, correct?
Potentially. They may be one and the same. Maybe a farmer that's also a rancher.
You said there might be other industries beside ethanol that would use your pipeline. What other industries can you think of?
Well, there's pre-combustion and post-combustion. So fertilizer plants, if you're talking post-combustion, it could be gas plants, other industrial processes.
Well, it's true, isn't it, that the advantage you have right now with the ethanol plants is you're just getting the CO2 from the fermentation process, which is essentially pure CO2, correct?
It's a nearly pure CO2 with constituents like oxygen and nitrogen, but it's nearly pure. So it's more cost effective to capture that CO2 than it would be from a coal-fired power plant.
Right. So if there's some other industry that wants to put the CO2 on your pipeline, it would take some extra equipment, extra expense, whatever, to bring that CO2 to a condition that it could be put on your pipeline, correct?
Yeah, assuming that's an industry other than an ethanol plant. That's fair.
Okay. And I'll ask Mr. Crowley about this, but for over 2 years now, all you've gotten for customers are 13 ethanol plants, correct?
In the state of Iowa.
Right, well,
I've asked him the same question, Mr. Taylor.
But even in the other states, there may be one fertilizer plant, I think, but otherwise it's all ethanol plants in the other states too, isn't it?
Well, I mean, we have other plants in South Dakota and Minnesota, but again, there's multiple projects in play. So some ethanol plants, I think, are on the sideline trying to decide who's going to have the first mover advantage. So there's a lot of opportunity out there. Hopefully, we're successful in gaining some more, but we have the capacity now and the throughput now to justify this project.
But after 2 years or more, you still don't have those signed, correct?
We have all the current plants signed under contract. Yes.
But the other ones you were talking about.
I'm more respectful of Mr. Paroli, Mr. Taylor. Again, we've got enough capacity now to justify the project. I will say, Mr. Taylor, sorry to interrupt your train of thought, with the footprint that we have configured in this state, we could add essentially double the number of plants with minimal impact. So the pipeline mileage would be less than we're currently asking for to be permitted in this application. So it would be beneficial to those plants and to, I think, the contribution to the state.
But if you add together the 13 plants you have, the plants that Navigator has signed up in Iowa, and the two plants that Wolf has signed up. There aren't very many ethanol plants left beyond that, are there, in Iowa?
There are others that I'm aware of. Mr. Crowley had to give you the exact number, but as you said, there are other industries. So there are other post-combustion opportunities that may be more costly on the front end, but that's an arrangement between Summit and that business or that industry to make that work.
But that certainly is an extra expense and extra challenge that those other plants would have that the ethanol plants don't have, correct?
The cost of development could potentially be higher.
Yeah. And in fact, the ethanol plants are just taking the CO2 from the fermentation process. They aren't taking the CO2 from their gas-fired energy system, are they?
You're saying that they have combined heat and power turbines?
Well, maybe ask it a different way. Aside from the fermentation process, the ethanol plants get their power for their boilers and their other machinery that they operate in the ethanol process by burning natural gas, correct?
I'm not sure if they all do. I know some do.
Well, I think Mr. Brookhammer said they all use gas, so I'll take his word for it.
And Mr. Crowley has a much deeper understanding of the ethanol plants, as he worked for an ethanol plant corporation before.
But assume that the general energy system in an ethanol plant is fired by gas. You're not getting CO2 from any of that part of the process, are you?
We are not at this time, and that's a fraction of the CO2 that's generated in the fermentation process. But that's a correct statement.
And there are ways, are there not, for the ethanol plants to qualify for the low carbon fuel standards without CCS, without the carbon capture and storage?
Not really. I mean, Mr. Perla can speak to this in more detail, but if you look at, and we've looked at this, if you look at installing a solar farm or wind turbines to power the facility, the ethanol facilities and the capture facilities, that may have a 3 to 5 point reduction in their CI by capturing these CO2 emissions off the front end of that process. That's a 25 to 30 point reduction in CI. So CCS is far and away the most significant way for an ethanol plant. Mr. Grohammer and others can speak to it better than I can, but it's by far and away the best option.
Yeah. Well, I will ask Mr. Grohammer. In fact, I did in his deposition. So
hopefully he said the same thing.
If it were not for the 45Q and 45Z tax credits, would someone even be doing this project?
Well, as I mentioned earlier, they won't be the only revenue stream for this project, but it is a contributor, absolutely.
Well, the question was, would Summit be doing this project without those tax credits?
You'll have to discuss economics with Mr. Paroli. I mean, I generally understand the economics, but I can't tell you if it's feasible without those or not.
I guess I would have thought the chief operating officer would know that much at least.
Well, I do know that they're available, and if they're available, and we can take advantage of that will contribute to our economics.
You told Mr. Jorde, I believe, when he was asking you about the geohazard review that you did, or the summit did, that there was a phase 1 and phase 2. I wasn't quite sure what those two phases are.
Phase 1 is a desktop where you evaluate what geohazards are present, and those are either what's available from geological services or what we've discovered in our surveys. And then if we think that the risk warrants, we, in consultation with our consultants, think that the risk warrants a phase 2. So phase 1 is essentially a desktop analysis. Phase 2 is a field level analysis. And so if the phase 1 risk, and the risk being the proximity of the geohazard to the pipeline, as that geohazard moved in the last 10, 20, 30, 40 years, those kinds of things, then if it's warranted, then we complete a phase 2 analysis. And typically, and I can't remember off the top of my head, in Iowa, Mr. Skubnik could probably address, typically that information is shared with, state geological officials.
And is there a report from that geohazard review?
There is a report. I can't tell you off the top of my head if I've seen a report for the phase 1 that's done in Iowa. But there either is or will be a report.
Isn't that something the board should have?
I have no issue with providing that report.
So when will that be produced?
Mr. Taylor, Mr. Skubnik will have to tell you if that report is available or when it will be available.
Mr. Whippel asked you about the pipeline being close to or inside city limits. As I looked at Exhibit B, which is the detailed maps that were filed with the Summit's application, it looked to me like the pipeline crosses into the city limits of New Hampton, near the south boundary of Charles City, close to the city limits of Rockford, close to the city limits of Gillette Grove, crosses into city limits of Goldfield. It's near the Eagle Grove city limits. It's close to the Dana city limits, crosses into the Nevada city limits, touches city limits of Superior, touches city limits of Erling, crosses into city limits of Shenandoah, and close to the city limits of Merrill. Do all those sound correct?
Well, I don't have those memorized, but I can tell you everywhere that we're connecting to an ethanol plant is typically in or near city limits.
And would you agree that many, if not most, of those cities probably have plans for expansion and development beyond the current city limits?
Again, we've covered that this morning, Mr. Taylor, but I'll repeat that we've worked with all these municipalities to the extent possible to identify where they had economic development plans. I'm not confirming that we've got those plans from every single one of those that you mentioned, but where we had that information, then we took that into consideration. And again, with the routing, as I mentioned before, there are many features and or avoidance areas and or constraints. And so navigating into an ethanol plant that is often in one of these areas, we took the most practical route with the least interference or restrictions to get into the plant.
So it's more important to get the pipe the ethanol plant than it is to try to protect the people in those cities?
No, that's not what I said. I said we're trying to find the best route into a plant to avoid as many areas as possible that may be restrictive, including the type you just mentioned. However, the business model is to capture ethanol, or CO2, from the ethanol plants. So we have to connect to those plants.
So again, what you're saying, it seems to me, is that it's more important to connect to the ethanol plants than it is to avoid those cities and the risks that those cities are concerned about.
Objection asked and answered.
I'll move on.
Thanks, Mr. Taylor.
I think you said in response to Mr. Whippel that the city of Erling that Summit didn't know until fairly recently that that was a problem, but wasn't that issue raised at the informational meeting back in October of 2021 in Harlan?
I never said anything about it not being a problem. I just said that our team has expended a lot of effort, whether that was satisfactory or not, to try to make sure that we understood economic development plans from these communities.
But do you agree that the concern about being close to the city of Erling was brought up at the informational meeting in October of 2021?
Mr. Taylor, we conducted 30 informational meetings in September and October of 21, so I can't remember that particular detail, no.
I'm looking at your educational and professional background. It looks like you've worked in the pipeline industry for a few years.
Yeah, pipeline, midstream, upstream, yes.
And how many of those were oil pipelines?
My whole career has been in the energy business, so it's oil, gas, refined products, ethanol in Brazil, and now CO2, natural gas.
Well, what I'm getting at is that for oil pipelines, how is the oil delivered to the oil pipeline from the well, so to speak?
From a gathering line. Or occasionally there's truck offloading locations. Preference is a gathering line pipeline, in my experience.
Well, if there were a spot shipper, so to speak, maybe I'm using the wrong term, but somebody who just, wants at a very short term or infrequently ship oil on the pipeline, the main pipeline, how does that oil get to that main pipeline?
You're talking about crude oil, not CO2.
Right, that crude oil.
Again, if it's it's a multifaceted scenario, right? So if it's a producer that's got a near-term need, then I work for Kinder Morgan, ran their projects and engineering, and then ran their operations. So if you come to me and say I've got X number of barrels for 6 months, I would suggest that you put up the capital, put in the infrastructure, connect to the pipeline, and if we had the capacity and you can meet the tariff requirements, you can ship on the pipeline.
What if it's just like a month-to-month thing?
Again, that's a business decision.
but oftentimes it would be transported by truck or maybe even rail.
Yeah, I mean, you probably remember that there was a lot of rail shipments out of North Dakota in 2013, 14. And, the preference was pipeline. And that's why Dakota Access was built, for one reason. And I built a pipeline out of North Dakota into Wyoming to move that product on pipeline versus rail.
And if I'm talking about just the way the spot shipper would get the oil to the main pipeline, that's what I mean.
That's one method.
I think you told Mr. Jorde that the capturing the carbon dioxide would require some machinery, equipment at the ethanol plant to capture that carbon dioxide.
Correct.
Okay. Just kind of give us a brief description of what that equipment is like.
So we'll receive the CO2 at near atmospheric pressure. So we'll put it through a package. It's called a blower skid. It increases the pressure to inject into the suction side of the compression train. So you have the blower skid, then you have the compression skid, which is a series of compressors that increase the pressure. And with that, the temperature increases as well. And then in the latter stages of those, you'll need multi-stage compression, all on one large skid. And we'll have a dehydration unit that pulls the water off of that train in the latter stages of decompression. So you'll have three big package units. And then on the back side, we'll have a discharge pump that discharges the dense phase CO2 into the pipeline.
If I read Mr. Phillips's Ernst & Young report correctly, that capture equipment for each ethanol plant would cost several $1 million. Does that sound right?
That's correct.
Okay. And I think he said $23 million. Does that sound right?
Well, the capital cost for the capture facilities, depending on the size of the facilities, if it's a one compressor, two compressor, three compressor train, one blower skid or two, it could range from that $15 to $25 million capital investment.
And is one advantage of your business plan, at least with the ethanol plants, is that Summit bears that expense?
I mean, again, I'm not familiar with all the commercial terms of the offtake agreements, but from a capital outlay perspective, I would think it would be beneficial for the ethanol plant that they do not have to finance the installation of the capture equipment.
That's all the questions I have. Thank you.
Thank you. Ms. Ryan.
Thank you. Good afternoon, Mr. Powell.
Good afternoon.
I want to start by going through your pre-filed testimony and asking some more specificity and clarity about some of the things that you wrote there. And I'm going to start on page 5, the very first line. You say demand for the project is high. Can you tell me how you measure demand?
At least in my opinion, that is measured by the amount of volume we have contracted.
So you've measured demand as a sort of after establishing the project.
Well, the 32 plants, the initial 32 plants, Summit Ag had an agreement with those plants before they formed the management team.
Do you know how early Summit Ag had agreements with those plants?
And I think that's a true statement. I know they had those discussions. I think they had agreements in place. Mr. Powell can confirm. No, I do not.
On page 6 in the second line, you mentioned additional rural jobs. What specifically will be the additional rural jobs?
Well, it's the jobs associated with the capture facilities and the pipeline, so direct hires and then indirect hires, so service providers, technicians, commodity type, oil, grease, gaskets, those kinds of things.
How many of those types of jobs will there be?
The direct jobs in Iowa, if I remember correctly, are in the 45 to 50 range. Indirect are typically 3 times, so I believe it was in the 170 range, and then there's another category, but in my OPEX budget, I've just accounted for what we think will be our buildup of direct hires and our service providers.
Can you tell me how many of those will be specifically rural jobs?
Most of those will be rural jobs.
And just for clarity, can you tell me what the distinction is between direct and indirect?
Direct would be a Summit employee. Indirect would be a third-party contractor or service provider.
And you would presumably contract with companies that are already in existence?
If they're available, yes.
On page 7 of your direct testimony, you mentioned a backup operations control center. At that point in time, you didn't have a location for it. Has there been a location determined for that yet?
No.
Do you know when that will be determined?
Probably when we've secured our permits as we go into construction, because it takes time to make sure that we've got infrastructure in place, etc.
Do you know if it'll be in Iowa or will it be one of the other states?
To be determined, but it will not be in the Des Moines or Ames area, because that's where the primary control center will be. So if there were a catastrophic event, hopefully not, in that area, then we would not want to jeopardize both control centers. So it could be in Sioux City, it could be in Sioux Falls, could be in Bismarck, somewhere else along the system.
And you also say that the project is being designed to transport supercritical or dense phase carbon dioxide. Will it be in the supercritical phase for the entire time that it's in the pipeline?
As I mentioned to Mr. Jorde this morning, there could be occasion where the product falls below the critical temperature threshold, and then it would fall back into a liquid phase versus a dense phase.
Are you able to predict at what points on the pipeline that will happen?
We have done a temperature study, and so evaluated or made assumptions around what the temperature will be at discharge and how quickly that will dissipate in the pipeline. Depends on ground temperature, etc., and then where that could happen and at what pressures that could happen.
So if it depends on ground temperature, does that mean that it's, in Iowa there's a pretty big difference in ground temperature between summer and winter. So will the phase of the carbon dioxide be different in different seasons?
No, it doesn't. The ground temperature doesn't have that big of an impact. It's really just how quickly the CO2 stabilizes as it leaves the discharge point in the capture facility. And is it 1 mile, 2 miles, or 3 miles down the pipeline before it stabilizes to a normal temperature?
By normal temperature, what do you mean by normal?
Mr. Skubanik is probably better suited to tell you this, but it's probably in that 60 to 70 degree range. It may be higher. He's better suited to tell you the details.
Okay.
He's the real engineer.
I'll ask him then. So you also mentioned that in addition to remote control operations, there will be local automated control. Where will local automated control be?
So there will be automated control, local control at the capture facilities, and there will actually be hands-off auto. The valves will be actuated mainline valves, and so there will be local control at the valve. So someone on site could cycle the valve manually. When I say manually, not with the hand wheel, but with the switch on site.
So it's not totally reliant on somebody sitting in the control center.
And you also say that operations personnel will be located in close proximity to those facilities? What do you mean by close proximity?
Well, in the capture facilities, they will be. And then along the pipeline, I mean, we haven't confirmed where we'll have operations offices, if you will, and maintenance workshops to be determined. But we'll have people that live along the pipeline. So they're not all going to be dispatched out of Sioux City to come, to span 100 miles, back east. So we'll have hopefully people that live along the pipeline route that don't have to report to the office every day, that can perform activities, whether it's damage prevention or other activities along the pipeline.
You said hopefully, so that means you're not certain?
Well, we've got to find those people and train those people up. So we're confident we can find them from tech schools and other industries. But we've got to start that process. We have to have those personnel. So where they have to import them, we find them locally.
Do you have any sort of guideline or ideal for, a certain number of miles in between people who are stationed along the route?
No, it's, I've operated pipeline systems where, it's 75 to 100 miles between where someone may be stationed. It really depends on the activities that are ongoing, if there's a capture facility, if there's a pump station, if there's a launcher receiver, those types of activities.
And along those lines, you mentioned that there will be personnel trained in maintenance and emergency response procedures. Will these be different personnel than the ones we were just discussing?
Our operations folks will all be trained in emergency response. Some will be trained in maintenance activities and some will not.
And I asked how far apart they were going to be, but I didn't ask how many in general are you looking to have in Iowa?
Along the pipeline route now, we're projecting about 220. But we'll bring on our operations supervisors as soon as we get permitted and start construction. And then they'll build up their own organization.
And if there were some sort of emergency, those would be the people who would sort of respond initially?
The summon employees, first responders in the communities in the area, and then Mr. Dillon will have to determine or make a recommendation around, OSREL is a bad acronym because it's oil spill response, but those third-party emergency response type folks, to see if we need those to augment the other resources available.
And I know earlier today you mentioned that you had talked with pretty much every emergency response team along the pipeline route. Have you talked with any local hospitals to see what kinds of needs they might have?
I'm not sure if Mr. Dillon has. He'll testify later in this proceeding.
I'll ask him. You also discussed a little bit about the incident in Satartia, and you pointed out that one of the reasons that PHMSA found for that incident was soil instability. Do you recall what kind of soil that pipeline was buried in?
I don't, but living in that part of the world, I'm assuming it was probably a high clay index.
Would you be surprised to know that it was less soil?
What kind of soil? Excuse me?
Less, L-O-E-S-S.
I know that a proper geohazard analysis wasn't performed.
Do you know what the topography was?
I do. I've been there.
Could you describe it?
Yeah, so it's a decline. The town of Satartia is very small. In fact, I would say there's probably 12 to 15 houses there, and it borders I believe it's the Yazoo River. The pipeline is uphill, maybe 100, 150 feet, and it's to the north of where this town of Satartia says. So there's a roadway, and then it sloughs off and goes downhill, and that's where the failure occurred.
Do you know if there are any less hills in Iowa?
I mean, you get into western Iowa, the topography changes for sure, and that's why the geohazard analysis is important.
Given that that was the kind of topography where the Satarsha incident occurred, is that the kind of area where you would do a phase 2 analysis?
Again, it depends on if you identify the hazard, and if you do, you do a phase 2. And it doesn't, not only do you have to do the appropriate level of analysis, you have to make sure that that's in your risk assessment, you have to make sure that that's in your integrity management program, and you have to make sure that that's in your operating and maintenance procedures. For instance, in my experience, in that part of the world where you have significant rainfall events in a very short period of time, anytime you have an event like that, you immediately dispatch people, either aerial surveillance or on foot or in a vehicle, to look at these high-risk areas to make sure that you still have the integrity after the event that you had before the event. And that wasn't done.
I have additional questions about your public awareness program. You said that you will incorporate all could affect HCAs into the public awareness program. So before I get into the specifics of that, we've heard a lot about high consequence areas today. Could you define that? I'm not sure I ever heard a good explanation of what exactly that is.
Well, as PHMSA defines a high consequence area, it's either a high populated area, which is 50,000 people or more with a density of 1,000 people per square mile, or it's an other populated area, which could be a lower population and less density or less dense. And it's navigable waterways, and then it's eco-sensitive areas.
So it's based, when it comes to people, it's based entirely on population, not on use.
I'm not on what, I'm sorry?
Use.
I think that's correct, from PHMSA's definition.
Okay. So if, for example, there were an educational facility with a large campus near the pipeline, it wouldn't have a great population, so it wouldn't be a high consequence area.
It may be an other populated area.
Maybe.
Again, it depends on how many people may be in that facility. But just because PHMSA doesn't classify it as a high consequence area doesn't mean that an operator doesn't take that into account for their risk assessment.
Do you take those things into consideration for determining the route?
We try to, yes.
So, going back to your public awareness program, you said you would incorporate all could affect HCAs. What is a could affect HCA?
Well, they're one and the same. The difference is a direct effect is where the pipeline traverses that area. A could effect is where the pipeline's in the vicinity but doesn't physically cross it. And so what we did on the disbursement modeling was looked at tracer scenarios. So anywhere that the pipeline was within, I believe it was 2 miles of a could effect, not the HCA, but a could effect. That's when we looked at the terrain aided or overland flow. And then also in the could affect areas, we established the boundaries of the could effects as a concentration of 15,000 parts per million, which is conservative, versus the 40,000 parts per million that Mr. Jorde showed on the buffer areas of the Navigator map. So the could affect area extended out broader than I would argue it normally would. And then we went 2 miles beyond that and did further evaluation.
So it says you're incorporating all could affect HCAs in the public awareness program.
If I said that, I misspoke, because the public awareness program will affect every landowner, whether the pipeline crosses their property or they're in the vicinity of the pipeline. So if you're in the area of the pipeline, you will be part of the public awareness program.
In the area, do you look at a certain sort of radius around it, within a certain distance? How do you define that?
There's some discretion there. Mr. Dillon could probably tell you what he's planning to do when he testifies, but generally you want to take a wide swath. So anybody that could potentially be impacted from road closures, any type of business interruption, direct effects obviously if the pipeline's crossing their property, you want to incorporate those. I think it's prudent to incorporate those people and those businesses into your public awareness plan.
Well, I want to follow up on some of the questions you were asked earlier today. I've tried to keep these somewhat organized, so I'm going to try not to repeat myself. I apologize if I do. Earlier today, you said you'd reached agreement with 73% of the landowners. Is that right?
Yes.
Is that 73%, and just for clarification, is that 73% of total landowners, total miles, or total parcels?
It's generally within 1%. We keep metrics on number of tracts or parcels, mileage, and number of landowners. And Mr. Roy can tell you exactly, but 73%, I always look at mileage. 70, it's actually about 73.5%. That's mileage. So tracts and landowners will be within 1% of that typically.
There was also some discussion about water usage and some water well permits for this process. Are those permits being obtained by Summit Carbon Solutions LLC?
They are being obtained by the capture entity. So Summit Capture, I probably got the name wrong, LLC, but it's the capture facility. So we have three entities: the capture, the pipeline, and the sequestration. The capture facility or the capture entity or business will secure those permits.
What's the corporate relationship? Is the capture facility is Summit Carbon Solutions a parent company of the capture facilities, or how is that relationship structured?
Yes, I believe that's correct.
Are the capture facilities also LLCs?
Not that I'm aware of. Mr. Crowley can confirm the structure.
I'll ask him about it. You also recently mentioned the total number of hazardous liquid pipelines in the U.S., and it sounded like a few 100,000. Is that right?
I believe it's about 230,000.
How many of those miles are carbon dioxide pipelines?
About 5,300. In about 11 states, primarily Wyoming, Texas, New Mexico.
I want to follow up a little bit more on your discussion of some of the emergency response issues. You said a couple of different times that volunteer fire departments tend to have a high turnover. What's your source for that information?
The fire chiefs themselves. I didn't realize that until Mr. Dillon meets with all these officials, but I've met with several across the footprint. And that's usually one of the first things that they mention is that how often will you provide training, and will you do ad hoc training because we have a high turnover. I always thought that volunteer firemen were there because that's what they like to do, not what they're getting paid to do. And so there wasn't a turnover, but apparently there is a high turnover. Now, I don't know if that's consistent across the state of Iowa in every area, but I have heard that many times.
You also talked about providing tactical response information to landowners in addition to emergency response agencies. What would be specific recommendations to landowners?
Well, Rod and his team will work with the emergency response professionals and the first responders. They'll develop response plans depending on the type of release or incident they're responding to. And then they will make the landowner aware of what that might look like. So, for instance, and Mr. Dillon will have to speak in more detail, but for instance, if we had a release, you're half a mile from the pipeline, and so the risk is X, and you shelter in place. And we'll have a reverse 911 for information, and this is how you'll be contacted by a first responder, if you will be, etc. Those kinds of things, so that if an event does happen, then the landowner has some idea of what to expect.
Is sheltering in place a common recommendation?
Yes, to my understanding it is. And we have some folks that can testify to that in more detail later in the week, but yes, it is.
Does sheltering in place help someone who's, say, working in the field?
Well, again, it depends on where they are and with respect or proximity to an incident, what the atmospheric conditions are, etc. I mean, we modeled worst case, so we modeled no crops in the field, no trees, worst case environmental conditions as I discussed with Mr. Jorde this morning. So you have to take into account any situation.
What would your advice be to someone who was out working in the field, didn't have any way to get to a building because all they have is combustion engines for transportation?
In what scenario?
A farmer?
But in what scenario are you talking about? What advice would I provide for what scenario?
Any scenario, any rupture.
Well, what I would tell you is that the likelihood or the probability of a release is going to be extremely low. And if you hear, it's like any product, whether it's CO2 or something else, another commodity, if you hear a noise or you see a cloud, and in CO2 release, you will see a vapor cloud, then yes, you go in the other direction, not in the direction toward the incident.
What about other facilities, if there are schools or nursing homes? Will those facilities get some sort of tactical response information?
Any business or landowner or homeowner that's in the proximity and that once Rod and the first responders determine what those responses look like and what the perimeter boundaries look like, if they're in those areas, they will be notified and communicated to.
And I've heard you mention a couple of times reverse 911. Could you explain to me how that works?
Well, it's my understanding that some municipalities, I don't think all, then have a reverse 911 number so you can call and get information. Mr. Dillon can explain how it works in detail. I'm not intimately familiar with it.
Do you have any idea of how many of the communities along the pipeline route have reverse 911 systems?
I do not, but that's the information that Rod will gather working with these first responder groups over the next 6 to 12 months.
So he hasn't gathered that information yet?
I think he has a conceptual idea, but I don't know if he's spoken to everyone. But, he'll be available to ask that question.
With respect to the ethanol plants, I noticed you referred to the ethanol plants as your partners. Do the ethanol plants have an ownership interest in Summit?
I defer that question to Mr. Powell.
You don't know if they have an ownership interest?
Well, they don't have an ownership. Let me say, I'm not sure if any of the ethanol plants or their shareholders have invested in Summit. As I told Mr. Jorde this morning, I don't know all the 400 plus investors in Summit Carbon Solutions. So some of those folks who are either are shareholders at the ethanol plant or employees of the ethanol plant may be investors, but I don't know that. So I can't confirm.
But as ethanol plants who are on your route, they are not considered, they don't have an ownership interest. If they have an ownership interest, they would have had to pursue it some other way.
I don't know if they have direct investment or not, but Mr. Crowley could answer that question.
Will the ethanol plants share in the 45Q tax credits?
And you're getting into the terms of the offtake agreements, and that's not my area of expertise. Mr. Crowley can answer that question.
Well, the 45Q tax credits will be a large source of revenue for Summit, correct?
That's fair.
And shouldn't you know as COO if part of that large portion of revenue is going to be shared with somebody else?
I've heard that a couple times today from Mr. Jorde. My responsibility is design, construction, and operation of the facility. I'm not the finance guy and I'm not the commercial guy. So they tell me that I tell them how much it's going to cost, and they tell me that we can finance that, and we have an economic model that's viable with that type of capital expenditure and that type of operating cost. But no, I don't have the details of that.
Who's responsible for the big picture economic scenario?
Well, that's Mr. Paroli, and that's our chief financial officer, which at this time is John Probst, and that's Lee Blank, the CEO.
Are either of them testifying?
Mr. Paroli is.
He's the CFO.
He's the chief commercial officer, CCO. John Probst is the finance guy. He's the CFO, and Lee's the CEO.
But neither of those last two individuals are testifying.
They are not.
You may need to have me ask this to someone else. With respect to the 45Q tax credits, has Summit used any tax equity financing?
We haven't used any tax equity financing, but I know the finance team has evaluated that, but I can't tell you the specifics.
You've mentioned several times that Summit has other sources of revenue. What are those sources of revenue?
I hate to keep doing this, but Mr. Paroli can confirm that there's tax credits. I mean, there's carbon credits and selling carbon credits. And Mr. Paroli can share the details around those and other opportunities. I don't want him building my pipeline, so he doesn't want me in his commercial business.
And you said that the ethanol plants will have the flexibility to sell into lower carbon markets. And I think at some point you mentioned potential international markets. Could you elaborate a little bit on that?
Well, and again, I'm not the commercial person, but there are obviously other markets outside of the West Coast and Canada that potentially you could a low carbon fuel supplier could sell into. Now, is it economically viable for them? I can't tell you that. I just know the markets, from what I understand, are expanding.
So you weren't speaking of any specific markets?
No.
And you said that it allows the flexibility for the ethanol plants to sell into low carbon fuel markets, but there's no guarantee that they will.
That's a choice for the ethanol provider.
When it came to choosing the route for the pipeline, did Summit consult with any other pipeline companies to see if there could be any coordination to avoid overlapping pipelines?
You mean existing pipelines or planned pipelines?
Either.
Well, you always have some limited conversation or communication with existing pipelines because you've got to understand what crossing agreements, crossing requirements, etc. are. But as far as Navigator or Wolf or others, no.
Did Summit consult with any regional or national organizations to discuss how Summit's project would fit into a national carbon dioxide infrastructure?
No. I personally did not. I know we've had some conversations with the Department of Energy. And I know PHMSA obviously has a connection to the Department of Energy and how CCS infrastructure may be built out in the future, but I have not been part of those conversations, if they've taken place.
Would there be another witness testifying who I could ask that question to?
The only one that I'm aware of that's testifying may be Jim, but I'm not sure if he was part of those conversations, if there were any of those conversations.
Is there someone who isn't testifying who would have been part of those conversations?
Not that I'm aware of.
There's been a lot of talk about what the intent of the pipeline is, and the intent is for it to be, the carbon dioxide to be sequestered. Is that a requirement in the contract with the ethanol plants?
Objection. State your objection. Questions regarding the content of the offtake agreements. Those have been held by the ALJ to be confidential, subject to attorney's eyes only. If the question is going to be asked, it needs to be in closed session, and it needs to be in front of those who have signed that attorney's eyes only confidentiality order.
I'll rephrase.
Thank you.
Is the intent for what happens to the carbon dioxide the type of provision that would be addressed in the offtake agreement?
I can't answer that. I'm not intimately familiar with the offtake agreements.
Then how do you know what the intent is of the ethanol plants?
How do I know what the intent of the ethanol plants is?
Yes.
Well, the intent's inferred for me in that we're going to capture a certain volume of CO2 that's been projected from their operations personnel, and we're going to put it in a pipeline, transport it, and sequester it in North Dakota. So that's my only insight into the intent.
Earlier, when you were talking to Mr. Jorde, you said that it's your understanding that Summit is incorporated in Delaware. Do you know for sure?
We are.
Do you know what additional states Summit has registered with the Secretary of State in?
I do not.
You indicated that a number of states, including Iowa, are looking at low carbon fuel standards. What's your source for saying that about Iowa?
It's just what I read and hear from our management team. So it's Colorado, and it's Iowa, and it's New Mexico, and it's Texas. So I don't know what the timelines are for those. Minnesota.
But you can't identify a specific source with respect to Iowa.
No.
Now, there was some discussion about the potential for enhanced oil recovery, which is fracking, correct?
Yes.
And if I recall correctly, you said that the oxygen level in the carbon dioxide is not correct for use in fracking,
Correct.
and that it would require construction of a, I think you called it a liquefaction facility?
Correct.
What all would be entailed in building a liquefaction facility?
Well, it would be serial number one. So I really wouldn't want to be the first to build a liquefaction facility of the size and scale it would take to reduce the oxygen content of 18 million tons of CO2. And it's really irrelevant because, as we've said many times today, the CO2 that will be captured from these ethanol facilities in Iowa will be sequestered permanently in North Dakota.
But you just said you don't have any source for knowing that that's the intent of the ethanol plants.
Well, I know whatever CO2 is transported from the ethanol plants will be sequestered in North Dakota. Because we don't have a means, or is there a plan to provide a means to transport that CO2 to an area where it can be used for enhanced oil recovery? There's no permit application in place that would allow that to happen.
Would Summit be willing to accept a condition on the permit that the carbon dioxide could only be transported for the purpose of permanent sequestration?
From the existing 12 facilities that we currently have under contract.
Sure.
Again, I'd have to consult with our legal team and the management team, but we would entertain that.
So when you were talking about your professional experience, you mentioned that you had experience working with ethanol in Brazil. Can you tell me when that was?
That was 2009 timeframe. I worked with BP and we had a project, actually a sugarcane ethanol project that was going in the wrong direction, and they sent me to Brazil for 6 months to get on the right track.
Was that low carbon ethanol?
No, that was just ethanol.
Where, I know that's been a little bit wild, but as far as ethanol in Brazil, where is that ethanol sold?
At that time, that ethanol was sold in the United States.
And I have one last question. I think it was Mr. Jorde was asking you a little bit about the security company Overwatch. Just one question about that. Do you know, is Overwatch's contract for providing security services here, is that held by Summit or the IUB?
Well, it's my understanding that Summit is responsible for all expenses incurred for all these proceedings, including security. It's secured by Summit.
So does that mean that Summit holds the contract with Overwatch?
We have a contract in place with Overwatch, and we amended that contract to include the resources that was requested by the utility board for this venue.
That's all my questions. Thank you.
Thank you. I think Mr. Murray? Go ahead. Go ahead and move that around, make yourself comfortable, whatever you need.
Very good. I am fine moving my chair if that makes it easier, but if not, we can go like this, okay? Good afternoon, Mr. Powell.
Good afternoon.
I have a couple of landowners I represent, so the good news is a lot of my questions have been eliminated, but I still have a few, okay?
Okay.
I couldn't help but notice that the IUB recently filed an order granting the Sierra Club's second motion to compel concerning the dispersion modeling documents and data. Are you aware of that?
Objection. I state your objection.
I don't know how it's possible that the witness that's been on the stand would be aware of the board's order that was published a few minutes ago. Mr. Powell,
I'm not aware.
I'm going to represent to you. It was email was just sent out on 4/25 granting that. Of course, limiting it to attorney eyes only, of course. My question to you is it Summit's intention to attempt to appeal that ruling to the district court, or does Summit intend on disclosing that dispersion modeling?
Objection, Your Honor. Invades attorney-client privilege. Obviously, we haven't had an opportunity to consult with our client about that yet. Thank you. Mr. Murray, do you have a response, or can we move on?
No, we can move on.
Thanks.
I think Mr. Long asked this question of you. Something about the nature of your company organization. But in there, I think you said something to the extent of, we are liable for damage to our pipeline. I think you were trying to give some assurance to Mr. Long that Summit is going to pick up any sort of liability for pipeline rupture. You would agree generally with that testimony you gave?
Yes. Yes.
Okay. Now, you don't mean yourself personally, do you?
No, I do not.
Summit is a limited liability company, is it not?
It is.
The owners are known as members, aren't they? An owner of an LLC is a member, isn't it?
It's my understanding.
Did you say you're an owner?
I have equity in the business, yes.
So that means you're a member, right?
Yes, but again, as we discussed earlier, we will have insurance.
I just want to make sure. I understand this because I own like stock in a company. I buy stocks in publicly traded companies, and so I understand it as a shareholder. I don't have any liability if that corporation gets sued, right? You would agree with that general statement, right?
I think that's correct.
So
Similarly, then you can be assured that there's no liability against you if a claim should come against Summit, correct?
Objection. Calls for a legal conclusion. Mr. Murray.
I think he's just testified as to liability and his knowledge of that. He certainly does have knowledge of the liability and limited liability of this corporation. As a COO, I certainly would think he would.
Okay, Mr. Powell, if you know the answer to that, you're welcome to answer. Otherwise, we
You
can
can
move on.
repeat the question, sir.
I'll restate it. We can be assured that there's no liability as to a claim against Summit with respect to yourself. You don't have any liability on that claim, do you?
I don't think I do. No.
And Mr. Raster is in a similar situation as well. He does not have that liability either, does he?
Objection. Same objection. Calls for a legal conclusion.
All right, thank you.
I'll withdraw it.
Thank you.
Can I purchase an interest in Summit?
Not at this time. You could have, but that equity raise is complete.
Is this company a publicly traded company?
No, as you just stated, it's not.
In the future, the public will not be informed as to the assets held and the debts owing by this LLC. Isn't that right?
Well, the reporting requirements for a private company are different than a publicly traded company.
So by your answer, I can assume that your answer is yes to that question. It will not be publicly disclosed, these issues of assets and liabilities of the company, correct?
Generally, that's correct.
So I'd like to turn to what I think you just referenced in one of your answers about insurance coverage, okay? With respect to the, I believe, the $35 million of insurance company, is it my understanding that Summit is going to provide such coverage?
Yes.
And would you agree that providing this coverage is a precondition to any permit that would be granted by the IUB?
Yes.
Did you testify earlier that one type of coverage that will be available is the coverage for loss of life and personal injury?
I did not testify to that.
Would it be included then as far as the loss of life and personal injury?
I'm not the insurance expert. So we can provide that information on what we think that coverage would look like, but I do not have those answers.
Okay, but maybe I misunderstood your answers to Ms. Grunhagen earlier when she asked you some similar questions about, or maybe it was Mr. Whippel, as to loss of life or personal injury. Do you remember him asking you these questions?
Yeah, I remember Mr. Whippel talking about livestock and whatever in the vicinity of a pipeline release.
So, as you sit here today, you cannot tell this board that someone who happens to be caught in a pipeline rupture and happens to die from asphyxiation, whether your company's insurance coverage will cover that claim, can you?
Objection, Your Honor. Calls for speculation. The witness has already testified that these insurance policies are not in existence at this time.
Thank you. Mr. Murray?
I believe that earlier testimony established that this witness has provided a data request to the OCA proclaiming a $35 million policy. I'm just asking about that.
And what the data request response says is $35 million in coverage. The witness did testify in response to Mr. Long's question that those insurance policies are not yet secured.
Mr. Powell, if you have knowledge of the policy and like to testify or would comment, please do so. Otherwise, Mr. Murray, please proceed.
I don't have knowledge of specifics in the policy yet because that hasn't been finalized.
Would you agree that the risk of pipeline rupture with CO2 is a risk to loss of life?
Well, I think a risk of a rupture of any pipeline, there is a risk of loss of life, but I would argue that the probability is extremely, extremely low.
So just like you hope that there are certain ethanol plants that come onto your line, I guess you hope that you have insurance coverage. Is that right?
No, I think you're obviously misstating the point. The point is that the reliability of pipelines is very, very high, and I don't believe we've had any deaths from the 47,000 miles of pipeline in Iowa to this point, and that's obviously very good. And I testified earlier that we will have insurance coverage that's adequate to support the risk of operating the pipeline in this state.
With respect to the duration of the pipeline permit you are seeking, I would imagine it's for the maximum period of 25 years.
Correct.
So, concerning the time value of money, would you agree with me that if you had $100 today, it grows over time? It's a fair estimation.
It depends on how you invest it. It sounds like you're a stock investor. You do a good job investing, it may grow.
I'm terrible at it.
Well, then you know it doesn't always grow, right?
But if you did put it in, say, a CD today, you could lock in, I think, 5%, right? Okay, so let's use 5%. Do you have any idea what that would grow to in a guaranteed rate of return over, say, 10 years?
You're talking about what would grow.
$100.
No, I can't do the math in my head.
It was hard for me. I had to get my calculator out. I'll suggest to you it was over $160, okay? And would you agree with me that it's fair to say that after 15 years, at 5%, that money would grow to over $200, right?
Okay.
Okay, so you have to trust a lawyer on math here for just a second. I know that's hard, but it would double in money over those 15 years, right?
Trusting your math.
Thank you. So $35 million today is not the same as $35 million in 15 years, correct?
Correct.
So
assuming the economy is sound and the value of the dollar is sound, etc. But as you know, you don't, at least in my experience, we don't enter into an insurance policy today and it's good for 35 years. That's probably renewable every year or every other year. Just like your risk profile is evaluated by that insurance carrier along that same timeline, and that cost of that premium and the value of that insurance may change.
that's the problem with fixing a rate, isn't it? We don't know. But there is the inflation rate, isn't there, right?
Especially today.
Well, so then if we were to say, suggest to Summit that it could increase its liability insurance coverage every 5 years based upon the inflation rate, would you agree to that?
Now, what I said earlier was that once we obtain permits, finalize the construction plan, and finalize the total cost and risk assessment, then we'll work with an insurance company to ensure the amount of insurance coverage that we think is adequate to support the risk. And the IUB can place whatever conditions they think is appropriate.
I think my question was, would Summit agree to this?
I'm not going to agree to anything like that without consultation with our management team.
In your direct testimony, you've testified to the impact of the proposed pipeline upon agriculture. Would you concede, obviously, that the taking of land by eminent domain is an impact on the agricultural use by landowners?
Well, it may be a yield deficiency impact, but again, a landowner that currently has that property in agricultural use can continue that use after the pipeline is installed.
So, are you saying that there is no impact on a landowner as to the use of this pipeline?
Well, the landowner won't be using the pipeline, I hope. But as far as using the land, after the construction is completed and the property or the right-of-way has been reclaimed, then the landowner can take it back to its initial use. So if that's planting, if it's an agricultural use, and it's corn, soybeans, or whatever, it's pasture grass, whatever the preferred use is.
This hearing began on August 22nd, 2023, I believe. Do you agree with the Iowa Farm Bureau witness, I believe his name is Mr. Johnson, who testifies that there are 187.41 miles that Summit has not secured land rights as of August 22nd?
That's close.
So to be clear, this Summit Pipeline private for-profit company is seeking the power of eminent domain over these 187 miles of land, correct?
Well, there's time between now and when the IUB makes a decision. So we secured over 500 miles of right-of-way, which is 1.5 times the amount of right-of-way that the Energy Transfer had to secure. So we still have a ways to go, but we still have time to negotiate with those landowners.
And I believe that we've talked about this earlier today, but I believe you had affirmed that this 187 miles would be...
It's actually 183.
183?
You're the math guy.
Yeah, thank you, appreciate that. So we're talking about a percentage of over 20% that's not signed up, right?
Correct.
I think you said in testimony earlier that 90% of that land is farmland?
Across the footprint.
Mr. Powell, I know we're in a kind of an awkward situation. Can you just make sure you're speaking into the mic? Go ahead and look at Mr. Murray. That's no problem. No, you're fine.
Okay. Yeah, but I believe that's generally the case across the footprint.
Now, did Summit oppose the legislation that came before the Iowa House earlier this year that required a 90% threshold before a hearing could commence?
I believe that's correct.
Is that because Summit knows it had little chance of reaching that threshold?
No, it's because Summit felt that the rules of the game were changing. So when we applied for a permit, that requirement was not in place. So after we applied for a permit with the IUB and began this project and began securing right-of-way, to change the rules in the game at a later time, we thought was not appropriate.
If land rights are taken, would you agree that those land rights should be limited strictly to the use that is necessary in order to facilitate the permit?
And you're speaking to specifically the installation and operation of the pipeline?
And the construction and the ingress egress that you see.
I would agree.
Now, we'll step through this rather slowly here just to walk through these different easements you have. But generally speaking, Summit seeks a permanent pipeline easement, correct?
Yes.
And that's generally a 50-foot wide easement in most cases, if I understand right.
Correct.
And also there is the temporary construction easement areas as well, correct?
Correct.
And then there's also this ingress-egress easement that is sought by Summit, correct?
In some cases, yes.
I see that the eminent domains rights within Summit's Exhibit H forms include a professional survey map that defines the permanent easement and the temporary construction easement areas. Would you agree with that?
Generally, yes.
There's also a description of what is known as the property, which is the landowner's parcel, which includes the permanent easement and temporary construction easement areas, correct?
From what I recall, yes.
So as I understand it, if we're talking about the property which is outside of the permanent easement and outside of the temporary construction easement, that area would simply be an area that is only for unimpeded ingress egress that is sought by the company, correct? That's the only use that you're looking for is ingress egress over the remainder of the property, right?
Yes, without looking at a specific plat, yes.
So I'll refer to that as the remainder of the property, okay?
Okay.
So I'll just represent to you that a sample Exhibit H includes language that limits the use of the remainder to be in the event of an emergency over such other portions of property. Would you agree with that characterization of Exhibit H?
Again, without looking at the specific Exhibit H, generally, I would agree with that.
Okay. Well, that word emergency is pretty important. Could you define emergency?
Well, emergency would be, I would hope to be a rare occurrence, so it wouldn't be normal maintenance, normal access. If we had a release or an incident and we had to access the property, that would be defined as an emergency.
I see. Would there be any other definitions of emergency besides a release?
It would have to be an incident that was specific to the pipeline. The pipeline was damaged in some way, or it could be if we ran an internal inspection tool and the tool discovered some damage that wasn't identified during construction, a dent, a gouge. In that case, that wouldn't necessarily constitute an emergency, but we'd have to access the property, and unless it's an emergency, which would be almost exclusively in response to an incident, then we would try to coordinate with the landowner when we could get in and do some investigation.
Thank you. So an incident, as you referenced, it is a release.
Or unless we knew someone was digging around the pipeline and struck the pipeline, but we didn't have a release, that would constitute an emergency for me to get in and assess the damage. But it would not be normal routine maintenance or operation of the pipeline.
Okay, so let's say the property in question, for this example, is a square 40-acre parcel with a road on the south side, okay?
Okay.
And I'm just going to suggest to you that in farmland, there's a farm access lane to these parcels, so let's put a farm lane on the southeast corner of this parcel, okay?
Okay.
Let's also suggest to you that in this parcel we have a pipeline that's located on the north side, runs east-west, on the far north side of the parcel.
Okay.
I'm going to suggest to you that this parcel is a quarter mile by a quarter mile. And I'm going to suggest to you that's what a square 40 is, okay?
Okay.
All right. So if you have an emergency, you're going to want to come on that southeast corner farm lane. Do I have that right?
Well, it depends on what access is available on the north side of the 40. Is it adjacent to a county road? Is there another access into it?
I'll explain further. My example is we have the road on the south side of this 40, okay? There is no road on any other side.
Okay. That makes it more clear.
Thank you. So if we have an emergency to that pipeline that's a quarter of a mile to the north, roughly, I would suggest to you that you're going to use that farmland in the southeast corner and proceed north, wouldn't you?
In that hypothetical, that makes sense.
Now, in this situation, let's just say that this farmer that has this parcel, that has this ingress-egress easement on the entire 40 acres, let's say he wants to subdivide that parcel and he wants to create an acreage that's 5 or 10 acres. That's the pretty typical size of an acreage. You would agree with that, wouldn't you?
I have no idea. I take your word for it.
They are. So let's say he puts it in the southwest corner of that 40-acre parcel. All right?
And the access was on the southeast corner?
Yes.
I'm just trying to keep track.
Yes. You're doing a good job. So, what would be the necessity to having an ingress-egress over that acreage?
What do you mean the necessity?
Well, what's the use of having any ingress-egress over that southwest 10 acres? You don't need it, do you?
I mean, simply put, we need a way to access the permanent right-of-way in an emergency situation. Whatever the easiest, least intrusive way to get there is what we need. Whether that's on the southeast corner, across someone else's property, if that's available, whatever that is.
The Exhibit H's that you filed with the board do not attempt to define any sort of limitations. It just takes a carte blanche ingress-egress over the entire parcel, the entire property. Wouldn't you agree?
Again, you're speaking hypotheticals, and there are a lot of Exhibit H's, and so based on your scenario, it sounds like the southeast corner would be the easiest point to access the property.
Not just the easiest, but the only real necessary ingress-egress that you need. Correct?
Again, in your hypothetical.
You would agree then, in the hypothetical. Yes?
In your hypothetical, without seeing anything other than what you described, a road on the south side, no road on the north side, a 5 to 10 acre tract being developed on the southwest corner, and the access road on the southeast corner.
It sounds to me like you agree with me then.
Again, in your hypothetical.
Thank you. You've answered some of these questions earlier, but is Summit going to continue to negotiate to secure land rights in the future?
Yeah, we're negotiating as we speak.
And I think you testified earlier that your goal is to sign 100% of all landowners, correct?
Yes.
Do you acknowledge that seeking the power of eminent domain constitutes a threat to landowners' rights?
I mean, that was brought up several times this morning. We're following the IUB process. So we're continuing to negotiate with landowners like we have for the last year and a half in Iowa. Regardless of whether they've received an Exhibit H or not, that hasn't changed the conversation.
Will Summit or its land agents use the fact that this hearing has started as leverage against landowners who have not yet signed up?
No. And unlike we've heard previously in some testimony, our land agents are prohibited from threatening eminent domain at any time. And if that happens, then they're terminated. And Mr. Roy can confirm that when he testifies later this week.
You've testified to this next question I have. I'm going to ask it in a different way just to make sure I understand. As it relates to negotiations focused on compensation, and for purposes of this question, it is compensation on an easement that has no other terms that have altered. Will Summit reduce its compensation being offered to landowners in the future, or will it continue to increase or remain at that level?
Well, I think what I testified to earlier, maybe was with Mr. Whippel, was that we would continue to discuss the most recent offer that a landowner had received.
So if no other terms are changing other than the discussion on compensation, is there a possibility that Summit is going to reduce its offer and compensation in the future?
That's not something we're currently planning.
It is a possibility that could happen, though.
Again, I'm not going to predict what's going to happen in 3 months, but currently we are actively negotiating with every landowner that has not signed an easement And that conversation is ongoing. No one is, to my knowledge, the conversation hasn't been, you will accept this or something else.
So if a right-of-way agent states that he has heard that Summit is going to go south on its compensation offers, you're saying that right-of-way agent is going to be terminated?
No, I didn't say that. I said if a right-of-way agent threatens the use of eminent domain, that right-of-way agent will be terminated.
So if a right-of-way agent were to say that Summit is planning on going south on compensation, or implies it, that's fair play in your game.
Well, again, Mr. Roy can speak better about his strategy, but generally in Iowa, Summit has offered some extraordinary premiums. And those were for landowners that worked with us early, and they were rewarded with those premiums. So will we continue to pay at those premiums? No, we've adjusted those all throughout the process. But as I stated earlier, if we're having a conversation with a landowner today, and we're talking about a certain compensation, we'll continue to talk about that level of compensation. We haven't threatened them with reducing it, to my knowledge.
As it relates to landowner communications, will Summit promptly respond to those landowners seeking to negotiate?
We typically always do. It's usually the other way around. Having a landowner who many are busy, especially if they're farmers, promptly responding to the agent.
So my question was, will Summit promptly respond?
Yes.
So when you acknowledge that Summit will promptly respond, what do you characterize as a prompt response?
I think that's a reasonable time frame of a couple of days.
A couple of days? Okay. On routing, as I understand your testimony earlier today, you testified, I think it was to Mr. Whippel perhaps. You might correct me if I'm wrong on this, but I think you said, I don't intend on amending the application as it relates to route. Did I hear you right?
That's correct.
Doesn't the statute require Summit's petition to discuss the availability of alternate routes?
Objection. Calls for a legal conclusion.
Mr. Murray, you want to rephrase your question? If you
Well then,
or reword.
Is it your testimony today that there are no alternate routes that you are putting before the board?
That's correct.
So I'm trying to understand the testimony you had with Ms. Gruenhagen earlier. I think you testified something to the extent that if a landowner is negotiating with Summit, perhaps Summit will be willing to change that route in the future. Is that right?
And what I said was, if the board provides flexibility to get outside of the route that we've represented in the Exhibit H's, then we could potentially do that. But now I'm bound by what's presented in the Exhibit H's.
So as I understand it, you're expecting landowners to prove up an alternative route to the IUB in order for you to then consider that alternative route. Do I have that right?
What I would suggest to you is that in many cases, we've been having conversations with landowners that would talk with us for well over a year. And as I mentioned this morning, we've made over 1,500 route adjustments. And as Mr. Jorde characterized them, micro adjustments, many of those are due to landowner preference. So landowners, including those that have received Exhibit H's, have had a lot of time to work with Summit to locate the pipeline on their property to accommodate their needs and use.
So, if I understand this correct, then it's Summit's view that it's not allowing for alternative routes, it's not petitioning for alternative routes at this time, and it's not doing so because the landowners that are left are out of luck.
Objection, Your Honor.
State your honor.
Misstates the testimony, mischaracterizes the requirements of the statute. Alternative routes are discussed in the testimony.
Mr. Murray, do you want to reword your question?
I'm just trying to understand this witness's testimony as it relates to alternative routes. Are you saying that then the landowner has the duty to prove the alternate route rather than Summit?
Objection, asked and answered.
Mr. Murray, I'd like to move on to a different question.
If there were different routes published by Summit in a previously recorded Exhibit H, but then an amended Exhibit H were changing that route, that can happen, right? In the past, I'm saying. That has happened.
I'll object to form. What's the question?
I'll reword. In a given parcel, Summit has amended its routes and amended its Exhibit H definition of that particular route on that particular parcel. That's happened, isn't it?
That may have happened.
Okay. So then, the prior route could be considered an alternate route. Wouldn't you agree?
Well, what I would agree is that the route as illustrated on the Exhibit H's that are current is the route.
But if Summit has done a survey of a prior route and filed that survey, that would be an alternate route, wouldn't it?
I'll object to the extent it calls for a legal conclusion as to alternative routes required by the statute.
Mr. Murray, do you have a response?
I'll withdraw the question. I have nothing further.
Okay. Ms. Coles, I believe you have some questions.
Yes, I do. Hello, Mr. Powell. Can you hear me?
Yes, ma'am.
Okay. I have a question for you. I'm Jean Coles Family Farms, LLC. I'm glad the gentleman did answer a lot of my questions I was concerned about relating insurance, etc. I want you to know that I can't get insurance as a landowner. So I hope you have better luck. Also, I want to know you're very proud of the 73% of people who voluntarily, say, sign the easement agreements. I'm wanting to know, did your land agents provide the landowners any hazard or risk analysis on the critical CO2 pipeline before they signed these easements?
Well, it depends on the landowner, but I myself have had many conversations, and I know our staff has and agents have, and in addition to construction professionals, drain tile professionals, and so trying to make sure that we answer all the questions that a landowner has, and then I trust that a landowner is comfortable and feels informed enough to make that decision.
Well, I asked several times over the course of a year and a half, and I didn't get an answer, and I had multiple land agents. Also, my tenants and other landowners that have signed the easement in the county are very concerned with what's coming out in this hearing and what they've learned over the last 6 months. They've had signer remorse.
I'm going to object to the form of the question for purposes of our record.
Thank you.
Excuse me, what was that again?
Go ahead and restate that, Brian.
Sure. I'm objecting to the form of the question for purposes of our record. I don't believe a question was actually asked. A statement was made.
Mr. Powell, do you think all landowners who signed early their easement agreements were aware of the critical state of the CO2 pipeline?
I can't speak to every single landowner, but my assumption is they felt well enough informed to feel comfortable signing a legal document.
Or were they not informed adequately to make a informed decision?
Ma'am, I can't determine for landowners how much information they feel is necessary for them to make the decision. I can tell you that we're available now for every landowner, whether they've signed an easement or not, to have a conversation around risk.
When I discussed several times the possibility of a route change, I was informed, no, that's the only safe way. There is no negotiation. And I had the same response over a year and a half.
Well, I'm sorry to hear that. That's a unique response because, as I've said, we've changed the route many times to accommodate a landowner's preference.
Why wouldn't they listen or present my concerns to your company or to the responsible party?
I can't answer that, ma'am.
Also, concerning, I'm letting you know how some of your land agents acted to me specifically. And I was, how can I say this? They pretty much told me that that this was as good as it was going to be on the easement agreement. It was completely underpriced for the value of my land. They also said I needed to sign now or they would file eminent domain. On July 7th, 2023, my farm manager, said absolutely not. On July 17th, they mailed me the eminent domain notification. So in that case, when they said, if you don't sign, we'll apply for eminent domain on your property, they did. What do you say to that?
Well, what I would encourage you to do is when Mr. Roy testifies, you ask him who that agent was, and he can confirm what happened there. And if that agent threatened you with eminent domain, they'll be terminated. And as far as Exhibit H's, we have to follow the IUB process, which means we have to file those Exhibit H's a certain time frame. And so that was following the process. It was unrelated to what may or may not have happened between yourself or your tenant and the agent.
Well, there was more than one agent. I think there were 4 different agents over that time frame, and they basically did the same thing. No further questions.
Okay, thank you. Seeing no more questions,